SJC-13393 in the matter of Patricia Ann Slavin.
So Attorney Itzkowitz, you're on your own here, huh?
I'm on my own, Your Honor. Thank you very much. Good morning, Your Honors. Mark Itzkowitz, and along with me, Ken Colpan, for the petitioner appellant, Kathleen Slavin. Your Honors, Ms. Slavin is in the court with her brother, one of her brothers. I understand other members of the family, not all of whom live in state, are actually monitoring on the virtual. And I only bring that up to point out that, as I pointed out in the brief, that the Slavin family is solidly behind Kathleen's efforts in this case. This is not the situation that had come up in the Marco case, where the administrator was trying to get around and keep money for herself. This is the family solidly behind. It's our position, Your Honor, that the law authorizes a voluntary personal representative to obtain additional authority by being formally appointed as personal representative beyond the 3-year limitation period of General Laws, Chapter 190B, Section 3108. And for that proposition, we rely on 4 sources of authority. The first is the nature of the voluntary personal representative status, voluntary personal representative provision itself, General Laws, Chapter 190B, Section 31201, which, as we suggest, is a type of informal proceeding.
Is that an appointment?
The language in the statute says it's an appointment. The last paragraph says that having gone through that process, the voluntary personal representative can get a certificate of appointment. Appointment is not a term defined by the statute. And in a document that was prepared by the judges of the probate court for the general edification of the public, they actually used the term official appointment. An official appointment is not a term defined by the statute. And the statute has a definition section that runs to approximately 40 different definitions that come up frequently in the statute. Appointment is not among them.
It seems like the court's drawing a distinction between formal and informal appointment by a judge versus the registrar, essentially.
It is, but that's part of the reason why it's important to keep in mind what 1201B is actually providing. This is not sort of self-help probate, as it were. This is not self-enforcing. I couldn't go in, for example, after we finish here today, I couldn't go up to the probate court, put down the filing fee, and say, I want to be appointed the voluntary representative of Mr. Colpan's estate. Forgive me. There's a bunch of materials that have to be submitted to the court for the court to review, to determine that, first of all, there is an estate that has to be, there is somebody that's...
You say these materials are submitted to the court. Are they? Are they submitted to the registrar?
They're submitted to the personnel of the probate court, for lack of a better way of putting it. It doesn't go to a judge. It doesn't have to go to a judge. It doesn't necessarily have to go to a clerk magistrate. Has to go to somebody, though, that has to review the requirements of the statute to make sure that whoever is applying has complied with those. And the form, which is included...
That person is who? The registrar?
There's nobody that's technically named in the statute to say that, it's this official. My experience, Your Honor, I mean, the statute, of course, is fairly new. It only dates about 12 years. But when I started practicing 40 years ago and was doing general practice with Carmen Durso, I would get sent up periodically to the probate court for various filings. And the way the process worked back then was that there was a wall, basically a long wall with a bunch of very thin shelving materials, sort of files, and you'd pick out the form that you thought you needed, and you would wait on a very long line, and eventually you'd get up to somebody, behind the counter, who would then review the form and tell you whether, yes, you filled out the right form and we'll let you go forward, or no, go back and take out form XYZ and fill that one out. The difference today is that this is all computerized, and you can fill this in the self-fill form, but it's basically the same process in the sense that it has to go to people within the probate court to review it. Now,
so did the voluntary personal representative get a certificate of appointment?
By statute, yes.
But no, actually, in fact.
The probate court, the MUPC guide says that the probate court judges say they will not give it. But when they say that, they say explicitly, they're very forthright about this, they say the statute states otherwise. The
And so because they're following that guide, they did not actually issue
That
a
appears to be-
certificate of appointment to your client?
Yes, that appears to be the case, Your Honor.
But
But
when
that
you,
guide
when you
lacks authority.
file, I'm just following up on Justice Wendland, when you actually file it electronically now, does anything come back saying you filed the right form, or nothing, it's into the ether?
You know, Your Honor, in this case, the form is electronic. I don't know whether you actually have to physically bring it into the probate court. That's what I've done. That's what Ms. Slavin did with her brother. I don't know if you can actually file that technically electronically, but somebody is reviewing it in any event.
So when you bring it to them, does someone say you filled out the right form? It's the same process now with just a little extra computerized?
Yes.
Okay, I got you.
Yeah, you have or you haven't. And what happened in this case, Your Honor, is that, for example, as you saw in the record appendix, there were a number of checks that were listed in the schedule in the voluntary personal representative application. And what happened was, after the death of her mother, these checks had come in for her mother, and the bank would not negotiate them because, of course, her mother is gone. And so she and her brother went to the probate court, because that's what the bank told them to do, and they said, what do we do? And somebody behind the counter said, well, there's a couple of different things you can do, because, again, that's the second point of authority, is that the MUPC and the probate code allow different options of ways to handle different issues as they arise. So the person behind the counter said, well, there's a couple of different things that you can do. All of them, for purposes of you negotiating these checks, will have exactly the same effect. So how big is this estate? What else is there? And she identified a car, and she identified these 3 checks. And there may have been something else, but it was all small, below the statutory threshold. And they said, well, you can file this document or you can file that document. And the difference, frankly, is $150, but they're both the same. You're going to come away with the same authority. The bank will cash the checks no matter which one you file. There's no reason to file the more expensive. Now, she's not acting as a lawyer, of course, and we're not suggesting that she is. And we're not even suggesting that whoever was behind the counter gave the wrong advice. Because based on the immediate problem of negotiating these 3 checks.
So the person behind the counter doesn't say, oh, by the way, is there a wrongful death action?
Exactly. And at that point in time, there was no wrongful death action. It was something that was looked into and came up with later. And so that's what brings us here today. So having obtained the authority, because, again, getting back to the statute, once she's appointed voluntary personal representative, she has legal status. She serves as the representative of her mother's estate. She has authority. And she can, according to the statute, she can conclusively bind the estate. She can collect and disperse assets. She can sell chattel. She can negotiate litigation. And she can convert it to cash. And everything that she does is conclusive with respect to the estate unless and until the probate court formally appoints somebody else to serve as personal representative. So she has authority. And getting back to, you asked about appointment, the language in 1201B uses the same terminology that comes up elsewhere. Appointment is one of those. It also refers to administration. So it says, for example, that the voluntary personal representative can be held liable for their misconduct in administering the estate. They can be held liable as a personal representative. That's the 7th paragraph of that. And there's nothing in any of the other language that says that this is not an informal proceeding. And in fact, the guide categorizes this as a type of informal proceeding. Okay? Technically, an informal proceeding may require a clerk magistrate, but again, we don't know who the person, that's passing on these papers is. They're not identifying themselves as a clerk magistrate necessarily, but somebody is passing on this.
Counsel, assuming you're correct in everything, what's the best result for? Is it for us to do it, to just make the decision, or is it to remand it with guidance to?
I would suggest both. I would suggest sort of a combination of both, Your Honor. One is, I think that the court can deem her appointed as the personal representative, and I would request that that be done. But I think that Your Honor's suggestion is very, very important, because quite honestly, especially when you're dealing with 1201, you're by and large dealing with people who are handling very small estates. They're not lawyers. They're not hiring lawyers. They're dealing with people behind the counter who, again, are giving good advice under the limited information that they have, but they're not acting as lawyers. And somebody needs to lay this out. And for example, the MUPC guide, which is the probate court trying to do this, acknowledges forthrightly that they're doing it, in violation of the language of the statute. So I would suggest that this is the court's opportunity to explain this, because there is no case law anywhere else in the country that we've found that addresses this issue. And the guidance, I think, would be critical, particularly for the judges to lay out, the probate court judges to lay out more effectively and more accurately what the authority is, so that, the lay person who comes in to take out a voluntary personal representative to cash a couple of checks or pay a couple of bills is properly educated as to what and how to do that.
Answer a question for me that, what happens to the personal representative if someone else comes in and is formally appointed? Is it vacated?
No.
Is there any?
No, it's not vacated, and that actually is part of the reason, again, why we're suggesting that the language, the other than language of 3108, allows the voluntary personal representative to get authority. Because among the other provisions of the statute, there's a section that says that the personal representative, once they're appointed, has explicit statutory authority under 3701 to ratify the acts of other people, meaning that the acts of the voluntary personal representative, if they're done for the benefit of the estate, can be ratified by now the formally appointed personal representative. And similarly, under the same provision, the actions of the formally appointed personal representative will relate back to the time when the voluntary personal representative had engaged in that action.
So you're saying basically this cross-pollination means that it's an appointment?
Yes. And it was anticipated, and it was provided for, and there's other language in the statute.
But obviously the probate judges think differently. That's what the guidance says.
It does, but again, they don't give any reasoning for why they're thinking differently. There's nothing in the guide. There's nothing in Judge Field's opinion.
Has anyone written? I mean, because we're at a disadvantage because this is a one-sided argument. Has another judge written anything that provides reasons on this, or?
Not that I found, Your Honor.
And is there there's no guidance on this interpretation?
No, Your Honor. And
because we tend not to have a court act irrationally. I'm just trying to get a sense of, and also it seems impractical what they're doing, but
yes.
Without any briefing on the other side, I just don't know why they're doing this. Yeah.
And Your Honor, I'm not a probate lawyer. Since my days as a general practitioner, I very seldom go into the probate court. I do mostly talking.
But let's say nonetheless you're right, that clearly under 1201, this estate fits because of its value. And let's assume also because of your cross-pollination that there's an appointment to be able to do certain things under 3108. What do you do with looking at, for instance, 31084, and where do you fit in and file a wrongful death claim?
Well,
Where's that fit into the powers that?
31084 will come up if there is no filing within the first 3 years. And I suspect in the not-too-distant future, Your Honors will get that case, because there's now at least 4 cases that I know of in the Superior Court where that issue has been before this.
So let's say that's right.
I'm sorry, Your Honor?
So that's right, too. Let's say you're right again.
Okay.
But, okay, now we know that 1201 gave the ability, based on, I think, the last paragraph, to do this. 3108, it's a good appointment. And 3 years, nothing's happened. And then, therefore, we go to the statute, and where do we find, and included in those powers is file a wrongful death claim.
Well, the wrongful death statute is independent of this. It's the.
I know, but look for instance, look at subsection 4. It's going to list all the things that the informal appointment or formal appointment or appointment proceeding, what they can do, right? There's things that they can do. And I'm just asking you, what is it that says that one of the things that they can do is file a wrongful death claim?
Well, that would, it doesn't explicitly say that in 31084, but of course, we're not under 31084, and that's why I say that that case will come before Your Honor, and the Superior Court has gone both ways. So there'll be, I suspect, people on both sides of the issue, and it'll be a much juicier argument than perhaps this one is.
Is the wrongful death action a property of the estate?
The wrongful death action and the survival action are both handled by the personal, are both, under the language of the Wrongful Death Act, they're both to be brought by executor or administrator. Those are the people allowed. What in the old days would have been a voluntary administrator was not allowed to bring a wrongful death action under the Marco case.
On behalf of the estate, but they certainly could if they were one of the people suffering the damages from the wrongful death. That is their own claim, as opposed
Well, that's
to a tort claim arising from the decedent's action.
And I apologize, Your Honor, I lost the question. I'm sorry.
Well, there's two sets of claims that happen when somebody is, has a wrongful death-esque experience. And one of them is the tort claims of the decedent, the person who was actually deceased. The other is the wrongful death statute, which gives rise to damages to the surviving members of the family. And those, as I understand it, are not property of the estate.
They're not property of the state, but the only person authorized to bring that case under the language of the wrongful death action is the executor or administrator. The language has not been updated to reflect the changes in terminology of the Uniform Probate Code. That's part of the reason why we say that Marco itself may in fact be somewhat in doubt, because the language hasn't been coordinated by the legislature. But still, that brings us back to the question that brought us to the probate court in the first place and now here, is that, just to resolve this issue and to avoid the possibility that maybe Ms. Slavin doesn't have the proper authority, we went to the probate court to get the proper authority, to have it explicitly stated that she is the personal representative, which under the current definition under the Uniform Probate Code includes both executor and administrator. That would clearly give her the authority to bring the wrongful death action. And in fact, because of the commentary, and again, there's no case law interpreting this yet, there's commentary from the drafters of the Uniform Probate Code that says that someone appointed executor in the will, and Ms. Slavin was appointed executor in the will, can bring that litigation even without being appointed formally or informally. But again, there's no case law interpreting it, and so that, again, leads us to come back just to put this issue to rest and make sure, everything is being done properly. So that's why we came back to the probate court.